What you're about to hear is not rumor. It's not speculation. It's not a headline. It's a man, under oath, being asked the simplest question imaginable. What did you plead guilty to? And realizing that the truth is too dangerous to say out loud. And from that moment on, everything collapses. Let's be very clear about what this is. This is a civil deposition recorded on video. No grandstanding, no rallies, no social media spin, just questions and answers, or more accurately, the refusal to answer. The witness is Jeffrey Epstein, and the transcript reads like a slow-motion confession wrapped in constitutional silence. The questioning begins calmly, methodically. Isn't it true that you kept a calendar schedule? A simple, factual question. Then, okay, change off the video record at 10:05 p.m. Already we're seeing control, management, awareness of what's being captured and when. This isn't a confused man. This is someone who understands records, timing, and exposure. Then comes the pivot. How long have you been sexually attracted to underage minor females? And instantly, chaos, objection, harassing, argumentative, move to strike. Why? Because that question goes straight to intent, and intent is radioactive. Now watch what happens next, because this is where people miss the significance. Epstein says, I don't feel like I'm divulging any secrets here, right? That's not denial, that's not outrage, that's calculation. He's weighing whether the truth is already public enough to say, and deciding it isn't safe. Then he drops the shield. I have to follow my attorney's advice. I must invoke my 5th, 6th, and 14th Amendment rights. Let's pause here. You invoke the 5th Amendment to avoid self-incrimination. You invoke the 6th when criminal exposure still exists. You invoke the 14th when due process is at stake. You do not invoke all three unless answering honestly could reopen criminal liability. That matters. Then comes the question that should have been easy. What was the name of any of the underage minors that were the subject of the criminal charges to which you pled guilty? His answer? I don't know. Let that sink in. A man pleads guilty in court and claims he doesn't know who the victims were. Not won't say. Not can't recall. I don't know. That's not amnesia. That's avoidance. The attorney presses again. So tell me about those charges. What were the allegations? Epstein responds, solicitation of prostitution. Notice what he does not say. He does not say underage. He does not say minors. He does not say girls. He says prostitution, stripped of age, context, and coercion. This is linguistic laundering. The lawyer gives him an opening. Okay, not underage prostitution, and Epstein jumps on it. Prostitution, but now comes the trap. Were the victims minors? Epstein retreats instantly. I pled guilty to solicitation of prostitution. That's not an answer. That's a legal label used to dodge factual reality. So the attorney does what juries love. He asks for facts. What did you do? Did you pull up in a car? Did they come to your house? How did this happen? In other words, tell us what actually occurred. Epstein's response? I don't know. Again, the man who ran global finance schemes, kept meticulous calendars, negotiated plea deals, suddenly doesn't know what he did, and now the exchange turns devastating. The lawyer asks, you don't know what you pled guilty to? Epstein says, I pled guilty to solicitation of prostitution, not underage prostitution. This is the moment the mask slips, because plea agreements don't erase facts. They don't erase victims, they don't erase ages, they just limit charges. And Epstein knows that. Then comes the question that detonates everything. The attorney states clearly on the record, these 3 females were procured by your method of having underage minor females locate other underage minor females and bring them to your house. Is that correct? This isn't speculation. This is an established pattern, already documented by investigators. And what happens? A wall of objections. Argumentative compound assumes facts, not in evidence, move to strike. Why? Because if Epstein answers yes, the entire plea deal collapses into something much darker. The lawyer simplifies it. Were all the people you engaged in sexual activity with underage and brought by other underage minors? Epstein's response, I don't understand the question. That may be the most unbelievable line in the entire deposition. He understood every financial contract, every offshore structure, every immunity clause. But not this? No jury would believe that? Finally, the attorney asks it in plain English. Isn't it true that you used underage minor females to bring other underage minor females to your house for sex? This is the core allegation, the heart of the case, the thing everyone wants answered, and Epstein does not deny it. He does not refute it. He does this instead. I would like to answer every one of your questions. My attorneys advised me I must assert my 5th, 6th, and 14th Amendment rights. That is not innocence. That is containment. Here's the key takeaway, and this is where segment 2 is going. Epstein never once says, no, they were adults. No, that didn't happen. No, that's false. He only says, I don't know. I don't understand. I invoke my rights. And in a courtroom, silence speaks. Let's start with the most important thing people misunderstand about this deposition. Jeffrey Epstein did not stay silent because the questions were unfair. He did not stay silent because he was confused. And he did not stay silent because this was some casual fishing expedition. He stayed silent because answering truthfully would have been worse than any headline. And here's why. In a civil deposition, invoking the Fifth Amendment is not neutral. In a criminal trial, silence cannot be used against you. But in a civil case, the jury is explicitly allowed to draw a negative inference. That means jurors are instructed in plain terms, if a witness refuses to answer on the grounds that it may incriminate them, you may infer that the answer would have been unfavorable. That's not opinion. That's black letter law. So every time Epstein says, I invoke, the jury hears, there is something here he cannot deny. Now, let's talk about the biggest dodge in this entire exchange. Solicitation of prostitution. Epstein repeats it like a spell. Why? Because it's the sanitized version of what happened. Charges are negotiated. Facts are not erased. You can plead down from armed robbery to theft. That doesn't mean there wasn't a gun. And in Epstein's case, investigators already knew the facts. The girls were underage. They were recruited by other underage girls. They were brought to his home. Sexual acts followed. Those facts didn't disappear because the charge was softened. This is why the lawyer keeps asking the same question different ways, not to harass, but to strip away legal camouflage. What were the underlying facts? What did you do? How did they come to you? And Epstein cannot answer a single one, not because he doesn't know, but because facts are harder to negotiate than charges. Now let's deal with the most absurd moment of the deposition. I don't know what I pled guilty to. Think about that. A man with teams of lawyers, months of negotiation, a carefully structured plea deal, claims he doesn't know what he did. That statement alone would destroy credibility in front of a jury because it signals one thing, selective memory, and juries hate selective memory. Then comes the nuclear question. The lawyer states the known recruitment method, underage girls bringing other underage girls. This is no longer a question. It's a summary of evidence. And Epstein doesn't say, that's false. That never happened. You're lying. Instead, he hides behind objections and constitutional rights. That matters, because denial costs nothing unless it's untrue. Let's be blunt. An innocent person can say, no. A guilty person says, I invoke. That's the difference. And notice something else. Epstein invokes not just the Fifth, but the Sixth and 14th Amendments. That's unusual. The Sixth relates to criminal prosecution. The 14th, to due process and equal protection. Why would those be relevant unless criminal exposure still existed? Unless the conduct being discussed could still trigger prosecution? Unless the truth was bigger than the plea deal? And here's the part that should make everyone uncomfortable. This deposition wasn't about whether Epstein abused minors. That was already established. This deposition was about how, who, and who else knew. Names, methods, networks. That's what he couldn't touch. Because once you describe the system, you expose everyone connected to it. Now look at how the deposition ends. Epstein suddenly goes on a fence. He claims prosecutors and lawyers fabricated cases. He portrays himself as a target of fraud. That's a classic tactic. When facts become deadly, you attack the process. But notice what he never does. He never denies the conduct, not once. So here's the uncomfortable truth people dance around. This deposition is worse than a confession. A confession admits one crime. This silence implies a pattern. A confession ends questions. This silence raises more. And that's why this transcript still matters, because it shows us something essential. Epstein didn't fear lies being exposed. He feared truths being spoken out loud. So ask yourself this: if the answers were harmless, if the girls were adults, if the recruitment didn't happen, Why not just say so? Why invoke 3 constitutional amendments? Why claim not to know what you pled guilty to? Why silence every time facts appear? That's the question this deposition leaves hanging. And it's one that still hasn't been answered, not really.